You got a lot to talk about, kid. There's so much happening out there, isn't there? I
There
mean,
sure is.
yeah. Let's so the first thing that people, we talked about this big beautiful bill earlier in the show, and I don't know if this was part of your docket today, and I'm not saying that you're going to be able to answer this question, but I am curious if you can, because you can come up with an answer better than I can. There is a provision in this bill that passed where it is making it so that courts cannot hold the president or administration in contempt. I am blindsiding you with this. I'm not letting you have the advantage of reading into it first. In general, though, if a bill in Congress says that, what is your gut on whether or not that can be enforced later on? They're saying that these contempt charges against Trump and in lower courts and higher courts of not that the administration is allowed to basically defy the courts.
Well, I think it's out of Congress's bailiwick. I think it's part of the separation of powers that the courts have that power. The courts had that power back in, Great Britain, even before we had the revolution and a constitution. And there's two kinds of civil contempts, Mike. One is a civil contempt. And I can't believe that the Congress or the president or them signing a bill could change that. So if court tells you to do something and you refuse to do it, you willfully fail to do it, the court can punish you by making you do it. Now, that's not considered a criminal contempt. Maybe punish is the wrong word, but until you comply with the order, you can be placed in custody. And so if you won't give them, let's say, the number to a Swiss bank account, and you've been ordered to give that number for the Swiss bank account by the court as part of discovery, as part of the litigation, and you say, I refuse. They say, well, until you turn over that number, you're going to sit in jail. And then you have the keys to the jailhouse door in your hand because you can comply. I can't believe they can touch civil contempt. I suppose they could abolish criminal contempt from the criminal code, and then there would be no statute in federal court that would be one for criminal contempt. But I just don't imagine that the law goes that far, because a lot of those criminal contempts could be seen as an obstruction of justice. They could be seen as an obstruction of judicial administration. And so they'd have to basically bar all of those bills. They'd have to basically abrogate them from the federal criminal code so that there wouldn't be violations for criminal contempt in court, obstruction of justice if it occurred in a court. Something like that if it occurred in a court proceeding. So I think where the rubber hits the road is on one of those flights. So now they're told that you can't put people either on a flight at all until there's been a further judicial determination, and some officer in Trump's administration puts them on a flight anyway, notwithstanding the court order. Or they're said, as happened with the people who were just sent to South Sudan, they say you can only be sent to one of those countries once you're legally deported, but you can only be deported to one of these three countries, let's say. Guess what? South Sudan is not on that list.
Right.
In 2 hours, we're not going back to your country of origin, and we're not sending you to country X or Y. You're going to South Sudan, and you have 2 hours. You can't get to court. You can't get a lawyer. You can't have any kind of process. And next thing you know, the flight takes off for South Sudan. The idea would be that you couldn't be held in contempt by the judge for that either. So I think, number one, this probably isn't going to work at all. And number two, I don't see the Senate, both sides, both houses of Congress have to agree. And I don't see that there are 4 Republican senators who wouldn't ditch that. I mean, we've had that for hundreds of years. It's such a it flies so in the face of what federal judges have been able to do. Judges can do that in state court. So I think it's a nothing burger.
All right. Well, that's good to know, because we are looking at these hungry people at the Mark Thompson Show are looking for nothing burgers in this bill, and to have one of those is great. I'll give myself a little bit of credit for saying I don't think it would make it through the Senate, but I don't know what they can do with it. David Katz, because he knows everything, says that in essence, I'm a little bit right about that. So I'll take that as a pat on the back from David. And now let's talk about a big story that is coming that came out of the Supreme Court today. It's an unusual Supreme Court story. We don't often get 4-4 ties because it's a 9-judge justice panel. But Amy Coney Barrett recused herself from this case. It's a case that the Supreme Court, in a 4-4 tie, means it goes to whatever the previous ruling was at the lower court, and it ends Oklahoma's bid to have a taxpayer-funded Catholic charter school. Tell me why this is important and how it got to that.
Well, it's very important to me personally because I'm getting into Pete Rose consecutive hits territory because I predicted this one.
And now, by the way, David, that means you're also eligible for the Hall of Fame because you've been stripped of your ban, which is great.
And I don't bet on law. I don't bet on law. I did a couple of.
That's the best line ever. I don't bet on law. All right, go ahead.
I did a couple of contingency cases, and I won a couple of them. And let me tell you, that's too rich even for my blood. And I came out winning. My friend said, "You come out losing one of these days. You'll really not like contingency fee litigation." So yeah, I don't bet on baseball, and I don't bet on law.
Okay.
But it's a fascinating case. And if I can get a little bit inside the it's establishment clause, but it's a fascinating case. And the reason that I guessed it right was I thought from his questioning that Roberts would go with the 3 liberals. And given the fact that Amy Coney Barrett recused herself, she doesn't have to state a reason, but she did recuse herself. And people have speculated that because of her connection with Notre Dame Law School, where she taught before she went on the circuit court and before she then went on the U.S. Supreme Court, but because of her affiliation with Notre Dame Law, and I think Notre Dame Law or one of its projects had been the attorneys for the religious schools that want to be charter schools. And I had
in particular, a very close friend of hers was on one of those in part of one of those groups from Notre Dame Law, someone who she's best friends with, which is why she.
And that's part of her whole affiliation, and she really did the right thing. And in trying to make my prediction, she did the right thing in recusing herself. You wish that Alito and Thomas would, they're right around people who are rightly recusing themselves. Why don't they rightly recuse themselves from some of those cases that they made the Supreme Court look so corrupt and tawdry, Alito and Thomas, by not following the rules, whether they're imposed by Congress or they're imposed by a judicial ethics panel that has teeth because they're the U.S. Supreme Court. Every right-thinking lawyer and judge knows that those 2 justices should have recused themselves from the cases that we've discussed. So she did the right thing ethically. She recused herself. That left it 4-4. And the reason I made the prediction was that I thought Justice Roberts would not have liked the headline. We don't have that many tabloids anymore. But the obvious headline was all Catholic judges rule everyone in America has to pay for Catholic schools. It had that look of 4 Catholic justices, or 5. It would have been 5 if he'd have joined the other side.
Yeah.
5 all Catholic justices make taxpayers of America pay for their Catholic schools. And Roberts had the good sense not to go down that road because that's what the case looked like. And it would have looked like they were establishing the Catholic religion in Catholic schools at taxpayer expense. And when people say, well, are they discriminating against religion? Are they infringing on the free exercise of religion? No, they're not. Because of our separation of powers, the Catholic Church doesn't have to pay in. They don't have to pay taxes on all those wonderful, until the acolytes came along, they used to make a profit. But all the money that the Catholic Church makes, all the real estate that they own and don't have to pay normal real estate taxes, all of the things where they have advantages because of the separation of church and state, to take all of those advantages fiscally and then to turn around and make all of us taxpayers pay for their Catholic schools. And this goes not just to Catholic schools. This would really hit a lot of people who probably don't care about it at all or think, wow, they're being unfair to the Catholic schools. My friend goes to Catholic school, really likes it, thinks it's great. This would also apply to madrasas, the Islamic schools. So we who are not Muslims would be paying for their madrasas. We who are not Catholics would be paying for Catholic schools. People who are not Jewish would be paying for some of these yeshivas. And in one of the cases that came out, they were talking about the yeshivas and how they don't even have instruction, many of them, in English. Some of their students end up leaving those schools not even speaking English well. They have instruction in Hebrew. they read the Talmud. That's all wonderful. You can have that religion and you can practice it that way. But again, why are we taxpayers paying for it? So the ins and outs of this case are it comes from Oklahoma. And you might think, oh my goodness. But they understand the justices on the Oklahoma State Supreme Court. They understand our Constitution and they understand Oklahoma's Constitution. And they understand that both of them have this separation of church and state. So when the charter schools come in, Mike, and there's over 4 million kids who are in charter schools are public schools. And that's where people have trouble understanding this case. But charter schools are just like public schools. That's why they get public funds. Now, they can emphasize math and science. They can have maybe higher disciplinary standards. So parents may want their kids to go to that charter school. But their curriculum is set forth and approved by the state. And if they were teaching the Catholic religion, if they were having catechism, if they were teaching the Quran and Muslim religion as a religious thing, not as a part of history, but as a religious thing, their curriculum would not be approved. They would not be approved as charter schools. So the next leap is, well, since you guys are making the taxpayers pay for charter schools, why shouldn't you make the taxpayers also pay for religious schools? And the Oklahoma Supreme Court said by a large majority, like 6-2, the Oklahoma Supreme Court said that would violate the separation of church and state. It would establish a religion with public funds in Oklahoma, and that would violate both the U.S. Supreme Court Constitution, the U.S. Constitution, and it would violate the Oklahoma Constitution. Since the Attorney General, and think what guts this guy has. He's the Republican Attorney General of Oklahoma, but he took this position because it's right under the Constitution. I doubt it's politically expedient for him. He'll probably be primaried.
Right.
But he took that position. And so because there's a federal question, does it or does it not violate the federal Constitution, that the U.S. Supreme Court could take it? It wasn't was just a finding under the Oklahoma State Constitution. It was also a finding under the federal Constitution. So it goes to the U.S. Supreme Court, but because it's a win, the tie goes to the winner below. And so the fact that you could not fund schools if they were religious with public funds, that having been the winning decision below, having been the ruling of the Oklahoma Supreme Court, the tie goes to affirming it. So that is still the law. So this religious school, this Catholic school in Oklahoma, has never gotten off the ground because of all of the litigation. But since it's a 4-4 tie, we say it doesn't have precedential value. It merely decided this case and avoided, in my opinion, a terrible ruling in this case had Roberts made it 5-3. If Roberts had made it 5-3, you don't like where your taxes are going right now. A lot of people out there listening, you don't like where they're going right now. They'd be going to pay for overtly Catholic catechism, Catholic schools, your nickel paying for that education. Now, the Supreme Court, last thing, has said that there are certain improvements at parochial Catholic religious schools, yeshivas, Islamic madrasas, that the state has to pay for. If the local schools are getting a new parking lot and they need a new parking lot because there's no room to park, yes, they can spend your tax dollars on building a parking lot at the madrasa or the Catholic school. And they can boost the tuition somewhat. And they can maybe pay for certain kinds of secular textbooks. So it's one of those. It's a good, it's a good bar question because it has a lot of intricacies. But this was too far. This was too far for Roberts. Roberts went with the other three. And I expect that there'll be some other state where they'll win. And that case will go to the Supreme Court. If that case tied, it would affirm that the taxpayers have to pay for the Catholic school in that state. So this is definitely wait to see what happens in the future, but just a fascinating case. And Katz got it right.
Katz got it right. Yeah, I've got my Katz got it right T-shirt. It's in the laundry, but he did get it right again. Let me ask you this, David. Some of you just said because one thing I was going to say is I don't know if it was the Oklahoma Supreme Court or the Maine Supreme Court on a case that was similar, kind of a cousin to this case. They also talked about how the more money goes into schools like charter schools, and if they were religious schools, the less money that would go into public schools, and it really would be a disservice to everyone who attends these public schools that are not religious schools. It would lead to I'm paraphrasing here, the further deterioration of public schools. Does that come into play in legal realm, or is that more in a political and sort of narrative realm?
I think that's more of a policy argument
Yeah,
because the charter schools are here to stay. More than 4 million people are in charter schools. They're
yeah,
opting out of the normal public school system, but because the curriculum and the other aspects of the charter schools are approved, they're deemed okay. And all of them are secular. None of them
right.
have this overt religious instruction. But the charter schools, as I say, they may emphasize STEM,
Of
more
course, yeah,
science and math. They may have higher disciplinary standards. People really worry that the kids who need special education don't have the same access to those charter schools, and so the normal schools have to deal with the more time-consuming, difficult students, and the meanwhile the charter schools get a holiday from them. And when they say
right.
that they're higher at this and they're higher than that, it's sort of self-selecting at some of those charter schools. But charter schools are here to stay. And if the Supreme Court ever says that the taxpayers have to pay for Catholic schools, overtly religious schools, there's going to be a huge backlash against charter schools, and people without kids, people who kind of hold their nose and tolerate the taxes that they pay
Yeah,
right now for schools without having kids themselves, are going to say, wait a second. Now I'm not only paying for these charter schools that seem to have all these advantages and none of the disadvantages. And then they brag about how they have better performance records because they try to take a slice of the overall students. But then on top of that, we're going to pay for religious schools. And like I said, the people who say when they had the argument, Mike, one of the justices, I think it was Kavanaugh, said. So all that's wrong with these charter schools, like the one that would be the Catholic one in Oklahoma, all that's wrong with it is religion. And the answer is yes, but that's everything that's wrong with it, because again, we have separation of powers and no one is discriminating against religion.
right.
Religions don't have to kick in to the kitty, and so they don't get to take money out of the kitty. It's really, really simple.
That's all that has to be wrong with them is religion. I mean, that's the bottom line here. Let me ask you a question about another case like this coming up that you alluded to earlier. How does that work legally? I'm asking. I'm curious. Like, so now that this has been rejected, what's the next type of case that this court may have to hear?
Well, some other state, I don't know, maybe it won't be Oklahoma, but pick any state. That state will decide that it wants to, in its charter school system, fund Catholic schools. Your local parochial school. They want to fund it. They want to authorize it as a charter school. Maybe it'll be close. They'll say, well, there won't be that much religious instruction or the religion, but it doesn't really work because the Catholics have every right in the world to have their religion and their dogma and their catechism and to teach it the way that they want to. And as long as they're going to do that, they're going to exclude non-believers. They're going to try to convert non-believers. And that is the religious instruction that under our separation of church
Right.
and state, the taxpayers don't pay for. But they'll go down that road. And they'll have some argument about how it's sort of not as religious as it looks. It's more secular than it looks, even though it's a Catholic school, even though it's a yeshiva. Maybe they won't be ones that teach so much Hebrew. Maybe they'll have much more instruction in English. They'll have some argument that all of their students are completely fluent in written and spoken English. And they'll go through the court system. And if the court system says that they are not violating the federal Constitution, it'll go back to the U.S. Supreme Court, and Amy Coney Barrett, maybe no one that she knows is working on that case, the one that has to do with the yeshiva or the madrasa, and that'll go to the Supreme Court. There'll be no precedent, and the argument will be, wait, it's more like the playgrounds, it's more like the tuition add-on that's been held to be constitutional by the Supreme Court, and that this is another step along that road, which is okay, and they may come back 5-4 on that.
And I guess that would make a plaintiff or somebody coming before the court more. I guess, optimistic, thinking, okay, well, we don't have Amy Coney Barrett's buddy in her
And
alma
don't
mater.
hire her friend. Whatever you do, don't hire her friend going anywhere near the U.S. Supreme Court. You know, there used to be a thing where they would hire a certain judge just because that judge would have to recuse themselves, you know, like the hanging judge. So you'd hire the buddy. We had this famous hanging judge here. He lived forever. And it's, supposedly people would hire a friend of the hanging judge just so the hanging judge would recuse himself. And so the biggest hanging judge in the Central District of California, you would hope that he wouldn't be on your case.
It's amazing. I love that. I love the intricacies.
All the legal machinations, right?
Yeah, it's fascinating. But kudos to Justice Coney Barrett for doing what as you said, many don't, and recusing when she knew that it was the right thing to do. So,
you know, RBG could have, when Obama said to her, you know, maybe it's time to step aside, she could have recommended one of her great law clerks, the same way that Breyer did with recommending Jackson, recommended one of her law clerks, and Obama and the Senate could have put her successor on there. RBGs. I mean, she got to be very, very famous, you know, we got Amy Coney Barrett when she didn't live as long as everyone who liked her hoped for. And then remember, they couldn't get Merrick Garland through because 10 months was way too close to the election.
It was so close to the election, David. You know that, yeah.
He died just weeks before the election, and somehow McConnell was all ready to go with Amy Coney Barrett, and they got her in weeks. When Merrick Garland, 10 months away, was way too close to a president.
It was way too close. By the way, it is why I say that Mitch McConnell,
right?
Yeah, total hypocrisy, but it's also why Mitch McConnell is a master politician. I mean, he was able to do that in two exactly opposite ways and have it be successful.
Trump said, "Where's my Roy Cohn?" And Democrats said, "Where's my Mitch McConnell?"
Right, exactly. No, it's really it was a remarkable turn of what happened there, and even still, like the way that they got Ketanji Brown Jackson meant that President Biden had Merrick Garland, because he would have had Doug Jones otherwise, and it would have been a very different, I think, Attorney General and Justice Department going after Trump, had it not been for Ketanji Brown Jackson. They had to make Garland the Attorney General, so there was a spot on the circuit court for Ketanji Brown Jackson, and that meant that Doug Jones wasn't the right person. Had Doug Jones been there, I think we would have had a lot more action against a former president under Biden. Of course.
You mean that Trump would be ranting from federal prison and not from the White House? He'd be ranting from the big house and not the White House?
Not the White House. Yeah, right. Yeah. Who knows? We don't know, but that's your little theory here from Michael Shore. Let me ask you this tonight. Speaking of our friend Trump, he is going to be at a dinner. And that dinner is what they're calling a crypto dinner that costs a ton of money to attend. It's the anonymous people who bought the Trump coin, with prices varying from like 55,000 to almost 40 million. And these people are going to be there and having dinner with the president. Many of them, they say over 150, seem to be foreign. The only one we know of is of a Chinese national who now has residence in St. Kitts and Nevis. How is this legal? And I ask that very seriously. What is legal about this?
Well, the U.S. Supreme Court, cut back on bribery cases and said that you had to have a very clear quid pro quo. And 9-0, they threw out the federal convictions of, I guess he was the governor of Virginia. And boy, it sure seemed awfully smarmy to me. But they said that this money that he took and these favors that he granted, there was not enough of a clear quid pro quo for that to be a violation of federal bribery statute. So I guess Trump, I'm sure, has asked some of his lawyers. I know that he doesn't have the greatest lawyers in the world in some of these positions, but I think giving him private advice, he pays the big money and he gets the good advice. So I think he's gotten good advice from somebody that this is not a criminal violation because there's no quid pro quo. He hasn't actually said, I will give you X if you buy my cryptocurrency. And since he hasn't said that, he feels like he's not liable for criminal prosecution. There's also the issue right now that since he controls all of the levers of government, who would be the one to prosecute him? Pam Bondi with the case investigated by Kash Patel. They're much more interested in whether some congresswoman shoved somebody or not during this melee up in New Jersey than anything that Trump is doing. So I guess you say, how is this legal? I guess we could say that those cases are wrongly decided and that this constitutes a quid pro quo. You get to have dinner with him and pitch him. The old argument always used to be that was access, that you weren't getting a favor, you were getting access.
So access is not considered quid pro quo. Is that what the case said?
The lobbying industry under Democrats as well as Republicans is based around the fact that you or me, we can't get an audience with so and so, but a former Democratic Congress member can get an audience, right, with let's say Biden or Clinton or whoever. So this is not something that the Republicans invented. That this idea that you can get access if you're a big contributor or you're a former Congress member or so forth. And some people would say that me being a former assistant U.S. attorney, people pay more attention in the U.S. attorney's office to what I have to say than if I had never held that post. But I certainly don't think that that's anything. I mean, I have a right to benefit from that experience, and I have a right to be, given a little bit more access, a little bit more credibility, what I have to say. But you can see that there's a huge leap from that to what Trump is doing right now.
Right.
So I guess to answer your question, I don't think there's anyone who's going to prosecute him for it or criminally investigate him for it. We can certainly talk about it in the media, and it's good the media is talking about it. And it certainly stinks to high heaven. But Trump has moved beyond the point. I mean, all of it stinks to high heaven. The plane for $400 million that he's conniving.
Very little doesn't.
No. Somehow it's going to go to the presidential library, but he's obviously conniving all this time to figure out some way that he can fly it. And if it takes $1 billion of the taxpayers' money to fix it up and it's not ready for 3 years, perfect, just in time for him to go check it out at the Trump Presidential Library and fly around on it all the time. He's utterly transparent. And you just think that these poor folks, especially when the economy goes down, Michael, when the economy goes down, and there he is standing next to Musk and the other ones and holding all these billions of dollars while the poor people are suffering. Their Medicaid's getting canceled. The rural hospitals are closing down. This Medicaid thing, if I can just say one thing, this idea that able-bodied people have to work and what's the big deal? Well, first of all, while the able-bodied people are proving that they can work or finding jobs, millions will lose their Medicaid coverage and so will their families and so forth. And then, dealing with bureaucratic agencies that, don't answer the phone and that don't do anything right. And, you're the guy who's working odd jobs. You're never going to prove to them that you're working enough to get your Medicaid benefits. You're going to be busting your ass out there working. You're going to be a Trump voter. You're going to be his kind of guy, his kind of gal. And he's going to cut your Medicaid. And then the hospital that you're used to going to or the clinic you're used to going to, there aren't enough people in that area with them getting cut back on Medicaid that hospital or clinic will stay open. You'll be driving miles and miles. Your jalopy is not going to be working that great. This is so awful for the Trump voters. This is a betrayal of his own voters on an epic scale. And his base will figure that out. He'll figure it out when it hurts. And it's really a pity it has to hurt, because if Harris were in there, it wouldn't hurt the Trump voters the way Trump is about to hurt them. And it's a terrible thing, because I have a big heart and I don't want to see any of them hurt, but I'm just predicting the future, I think, pretty accurately on this one. He's really going to hurt his own voters.
There's very little precedent in American electoral history for people voting against their own interests as there was in 2024. Whether you liked Kamala Harris or not, the MAGA people are the people that in today's big, beautiful bill are being trashed. They're being hurt so much. And I'm not talking about obviously the wealthy and the corporate people who support a Republican president. I'm talking about the people that go to rallies and get in cars and they move, like migrants across the country to see this guy during that campaign. The type of people that come out who I got a chance to speak to over and over and over again. These are the people that are being hurt by today's bill and by an us versus them mentality that informs this White House and this president, and they don't know it. And I know what you mean. You feel badly for them.
Mike, Mike, you should really write a book because you had that experience of seeing that campaign unfold and you saw something really remarkable. Who were those two who wrote that famous book? Was it about Clinton? But you got a book in you, dude.
Yeah. All right. Well, there is a book. There are two books I want to write, and that's one of them, and I should. And all right, now there's pressure. There's pressure from David Katz. He's eligible for the Hall of Fame. How do I argue? And I will buy the Katz coin. By the way, you were talking about that my influence as a former U.S. attorney or district attorney. Well, if you start selling Katz coins, I'm going to buy Katz coins.
Well, if you get your book out by Christmas, I promise I'll order for you because I find that thing interesting. I mean, not turning it on every night. I'm sure you heard the same speech over and over again, but
Yeah.
still different things that happened in different places and
No question. And the speech wasn't what mattered. I always found that a lot of those people were there for the tailgate more than they were for the game. And what he said under that roof didn't matter as much as what was happening in the parking lot after and before. So yeah, okay.
we have a few minutes to talk about the saga of Trevor Kirk, or it's not that interesting to your viewers. He's the police sheriff in California.
Yeah, absolutely. I think the Trevor Kirk story is fascinating, and I don't think you could talk about anything here that would not be fascinating to our viewers, to be frank. So this is that case in Lancaster, California.
I checked a half an hour before we went on the air, and there's no ruling from the federal district judge yet about it. The facts are that a deputy sheriff goes to Lancaster. It's far north, but it's part of LA County, but it's far north. It's not the image that people have of, Beverly Hills or downtown LA. So this deputy sheriff goes out there with a partner. Two of them go out there on a robbery call to this exurb called Lancaster. And this woman is there. And the minute that the sheriffs arrive, she's taking a photo. She's taking a YouTube video with her camera. And I'm sure she has a little bit of attitude, which she has every right to do. This is the First Amendment. This is a free country. And she's saying something like, I got this on YouTube, and you better be sure you give the accused his rights, tell him what he's been arrested for. And apparently this deputy gets out there and he takes one look at her and hears what she has to say, and he goes into a fury. And at least according to the evidence presented at trial, he doesn't give her any commands. He throws her to the ground. He handcuffs her. He shoots pepper spray in her face at least twice. And all of this is on camera because she was indeed filming, and they've got this film. So with this kind of evidence, and you sort of need this even currently to prosecute a police officer or sheriff, they have this open and shut case on video from their point of view against him. So he's prosecuted, and he's offered a misdemeanor. And he won't take the misdemeanor, the federal misdemeanor. He wants to go to trial. So he goes to trial, and they show the video, and he loses. And so in February, he's found guilty of this use of excessive force and assault with a deadly weapon, because under the code, it is a deadly weapon, pepper spray. And she's rushed to the hospital. She sustained injuries. She files a civil suit. So now we're in February, and Trump is, getting inaugurated January 20th. Within a couple of months, he's hired a new U.S. attorney. Not like I was an assistant U.S. attorney. I had a supervisory position there for a while, but he was the U.S. attorney chosen by the president, this new one. And this new Trumpy one comes in, manages my old office, and says, no, we're not proceeding on this case. We're going to make him the same old plea offer we made him before the trial, and we're going to give him a misdemeanor. And the cherry on top is we're going to recommend that he get no jail time. Now, it's been reported that his probation report, prepared by the federal probation officer, which is part of the federal court system, the probation officer has looked at both sides and all sides of this, and his or her recommendation is like a 6-year prison sentence. Now they're going to make a new plea agreement that knocks this down to a misdemeanor, and that says that the government is going to ask for no time. So the three assistant U.S. attorneys who prosecuted this case before the jury and got the guilty felony verdict in federal court, they all quit. So it's another case like the Mayor Adams case in New York City, where the career assistant U.S. attorneys who know this case inside and out said, I can't live with this. I quit. I'm not signing anything. And the supervisor quits. And that leaves the new Trumpy U.S. attorney to go find someone in the U.S. attorney's office who will sign this plea agreement offering him a mere misdemeanor and no jail time. And as fate would have it, that's a prosecutor that I have on a big white collar case of mine for years. So suddenly I have this case, which is not newsworthy, and I have the most famous assistant U.S. attorney in America on my case. Interesting. His name is Rob Keenan. Nice guy. Rob Keenan signs these papers, and Rob Keenan ends up in federal court on Monday in a 2-hour hearing with this federal judge who keeps saying, wait a second, I was here. I heard the evidence. I saw the videotape. I've had a motion that I should acquit this deputy sheriff. I've denied it. I don't see any basis why you guys are going to change what the jury did, in which I saw. I'm about ready to proceed with sentencing of this deputy sheriff. So they have a 2-hour knockdown dragout, and all the friends of the deputy sheriff are there. Our former sheriff Villanueva is in the courtroom. Our current sheriff is in the courtroom. This Trumpy new U.S. attorney himself is in the courtroom. He apparently gets into it with the civil attorney for the black lady who was pepper sprayed and thrown to the ground. And he says, you can be removed from the courtroom. And she's saying, you're not the judge. You can remove me from the courtroom. Apparently, it was a hearing for the ages. Unfortunately, I wasn't there. The journalist in me would have loved to have been there. And now the judge has taken it under submission and is going to rule supposedly later this week. So the prosecutor, this Rob Keenan that I've had this case with now for years, nothing to do with this whatsoever.
Right.
He says, we were thinking of doing 3 things with this case. Just leave it alone and you impose the sentence that you impose. I guess we would ask for a lower sentence, a much lower sentence. If the probation is going to ask for 6 years and he's going to ask for no time.
Zero. Yeah.
Time at all. That's a little different. Or we're going to come and do what we're doing, which is say, you know what, you should give them throw out the jury verdict, throw out the felony. She wasn't injured. Apparently, as soon as he says she wasn't injured, everybody goes crazy in the courtroom because the lady is there testifying. She's allowed to make her victim impact statement about how she was rushed to the hospital. Of course, she was injured. Right. What are they talking about? Pepper sprays in the eyes. Pepper spray is a deadly weapon under California definitional law. Or we could drop the whole case. Now, this is what I think is really interesting for your viewers, and I want to touch on this. This gets us to Mayor Adams. The federal government does have a right under the separation of powers. They're the only agency that prosecutes. Congress has the power of purse. They do what they do. The courts decide all sorts of interesting things. But who prosecutes? There was a special prosecutor under statute for a while, and we have, Jack Smith, how he became a prosecutor. But basically, the president of the United States, especially under this unitary executive theory, that's the one, the executive branch, the U.S. attorney. There's nobody else to prosecute. So if the judge says, like in the Mayor Adams case, who would have actually tried Mayor Adams, right? If the judge had said, I'm not dismissing this case, but this one's an anomaly, Mike. This one's different because there's already a probation report. There's already been a trial, okay? All that has to happen now is the sentencing. If the government says, we don't want to participate, the judge can say, good, don't participate. I'm reading the probation report. I was here for the trial. I'm ready to sentence the person. And another irony is that there used to be a judge in federal court when I was an assistant U.S. attorney who didn't want to hear from us at sentencing. He said, you know what? I've read the probation report. I've been doing this for decades. I don't need to hear from the government. So he didn't hear from the government at all. So the idea that it's not proper to have this sentencing, the judge could go ahead and sentence. And then the interesting thing, which I'm dying to see, and I think what's going to happen, by the way, the judge in the case is a Republican appointed by Reagan, but he's, so far as I can see right now, he's getting this one right. I think he's going to say, no, I'm ready to go ahead with sentencing. The jury found him guilty of a felony in front of me. I've got a report from probation. If the government would like to make a recommendation why I shouldn't give the much higher sentence recommended by the probation department, I'll hear what you have to say. If you don't want to participate, don't participate. And then it would go up on appeal, right? And I guess if the government doesn't want to defend it on appeal, I don't know. I guess the Court of Appeals, I think, has the power to appoint a special prosecutor just for the purpose of filing a brief. That's what the judge in New York did with the Mayor Adams case. He did appoint an outside attorney that he had high regard for to file a brief to tell him what should I do in this situation. I think the Ninth Circuit could appoint a lawyer to say, here's what you ought to do in this situation. And I suppose the real question is, was it a fair trial? And if it was a fair trial, the Ninth Circuit could affirm the conviction. They could affirm the sentence. And so there's that option. And so what my adversary, Rob Keenan, what he told the court was, we also considered a third option, Your Honor, which was just to dismiss the case entirely. And apparently they would have the power to dismiss the case entirely.
Even if a jury has ruled, even if a jury has already given a decision?
Very hard to figure out. That's a great question. And it's a very interesting legal issue. And then by saying that dismiss the case entirely, he's sort of telling the judge, right? He didn't ask to dismiss the case entirely, but he also made it clear what they might do if the judge says, no, I'm not going to do this misdemeanor deal. I'm going to sentence him. I'm ready to go with the sentencing. That's going to be June 3rd is going to be the sentencing if they go ahead with the sentencing, which I think is what the judge is going to do. I'm putting my Katz on the line here, but I think that's what the judge is going to do. And then the question is, does Trump pardon him? Now, if he pardons him, that's it. Game over, right? He could have been convicted. He could be about to go into prison.
And that's
Trump pardoned some people who had one step outside the prison gate and one step in the prison gate. He yanked some of these people back right out of prison, and he yanked some of these people directly out of the prison. They weren't 1 foot in the prison and out of the prison. They were both feet in the prison, incarcerated. He cut some of those people loose. I think that Trump does not want the juxtaposition of Trump talking about how he's against this and he's against that, and they show that tape. The fact that there's a tape, and you can see that woman just jumped on. She's not given any commands. She's not told to stop. She's not told calm it down. He sees what's going on, the deputy sheriff. He jumps on her. He throws her to the ground. He pepper sprays her. They argued in court. My adversary, this Rob Keenan, apparently argued in court. He said, you got to say this. The deputy sheriff certainly didn't have good communication skills. Wow. Is that the understatement of all time?
That is the understatement of all time. No
communication skills. He had attacked this woman who hadn't attacked him or done anything. He had a right to use any force against her at all. He didn't just have a lack of communication skills. So that's what's happening, and the case really should have a lot more publicity. But it happened here in LA. It happened a while ago, back in 2023, and she didn't die. She didn't sustain.
Right. And I would argue too that the more publicity it has, the more likely the president would be, and I guess sort of inclined to get involved. I think if it's a low-level case, perhaps he would want to stay out of it because it just.
Well, Villanueva and his other people supposedly made a big issue of this. And the new U.S. attorney, while he is himself a former assistant U.S. attorney like me from that office, he didn't follow the normal career path after the U.S. attorney's office. He ran for a state political office, and he was elected as a Republican, very law and order, out in Riverside or someplace like that, a very Republican area. And then he was a very Trumpy legislator. And then Trump picked him, I think, much more as a Trumpy legislator than he picked him as a distinguished former assistant U.S. attorney, which normally is the way you become the U.S. attorney. You're someone who really stood out and got great acclaim legally. I don't think they've ever picked a former politician. Can I digress with one last thing?
Of course you can. This is your courtroom.
Thank you. I was hired by Steve Trott in 1983 to be an assistant U.S. attorney. And Steve Trott was distinguished in several ways. He had been a deputy district attorney, and he'd been up in those days to be the district attorney. He lost out to someone named Robert Filibosian, and he was an incredibly talented person. And Reagan said, I don't care if he wasn't a federal prosecutor. He was a state prosecutor. He did all of these big cases. I think he'd worked on Manson. Then he had two crazy brothers or cousins who'd done some horrible thing, and he'd gotten them both convicted. I mean, Steve Trott was the real deal as a prosecutor. And he became the U.S. attorney, even though he'd never been an assistant U.S. attorney. I think he's the only one. I know what you're going to say. Judge Jeanine Pirro has never been a federal prosecutor.
I was
Steve
about
Fry
to
should
mention.
never, ever be mentioned in the same sentence as Judge Janine Pirro. So after he was the U.S. attorney and I was in love with him and I was looking forward to working for him all those years that I signed on for, he went off to become a huge Justice Department official just months after I started. And then he has been a judge on the Ninth Circuit, and he's still a judge on the Ninth Circuit. So the point that I'm making is that you can come not from the normal route. So I don't hold that against him. But this new U.S. attorney, Mike, has really taken, I think, an extreme position on this case. And so here's my prediction. My prediction, and the judge hasn't ruled
That's
yet.
what we're all waiting to bet on.
Okay. I think that this federal judge is not going to throw out the felony jury verdict.
Right.
I think that he is going to go ahead and sentence on June 3rd. I think that he's probably going to give him some prison time, but not as much as probation's asking for, but also not no time. Yeah. I think he's going to give him bail pending appeal so that the police officer doesn't actually go into prison just in case the judge is wrong. And that's going to go up to the Ninth Circuit like that, with him sentenced on the felony, with him sentenced to some time in prison, but with bail pending appeal. And then the Ninth Circuit will unravel all of this. And I don't think that Trump, at least for now, if the guy's not actually incarcerated, which he wouldn't be under my prediction, I don't think that Trump will actually spend his political capital on giving this guy a pardon and having that videotape shown, because then the videotape would be shown in an endless loop on television along with Trump's pardon. How could you pardon something like this? This was so beyond the pale for an officer.
Well, there's a little bit of video from January 6th too, David, and he found a way to pardon those people too. So I'm never say never.
That became so integral to him. Even with J.D. Vance saying we'll never pardon any of the violent ones, and the senator saying we'll never pardon the ones who attacked a police officer. He did all of that.
Of course he did.
He pardoned them up to the worst of the worst, the double-digit sentence people. No. But he had gotten way too invested in that one.
He had, and those were, and it's different. I know. I was just saying that when you think video is going to happen, and
Mark always says that to me.
Yeah.
But if Mark's watching, he's laughing right now. He's saying, Katz is right on all these things, but to be all the way right, we got to see Abrego Garcia. Abrego Garcia has to be back on American soil. That one's still pending.
That's pending, but there's no expiration, right? I mean, Katsadamas is it doesn't have a deadline. So did you see? By the way, I don't know if this is a new thing or not, but it's the first time I'd seen the Katsadamas portrait that was just on the screen.
Beautiful likeness.
It is a beautiful likeness. It's fantastic. Well, there he is, David Katz. Man, I
used to wear my glasses more before my cataract surgery.
Oh,
my glasses more. So here we go.
So there you go. And that's the Katsadamas we all know, right?
Never had a beard. Never had a beard, but Nostradamus.
You can borrow mine.
But Nostradamus did.
Nostradamus did, because you have to go like this, I think, if you. But thank you. I tell you, I enjoy our time together every single Thursday that I do this, and it's really been a pleasure. And I also feel relieved because I know so much more about all of these cases, certainly the Trevor Kirk, but also the way that they approach these things in the Supreme Court and the recusal and all that than I did before we started our chat. So thank you. Have a great weekend. Mark will be back here with you next Thursday, and by then maybe we'll know a little bit about the judge, as they say it could happen today or tomorrow, what the judge did in the Trevor Kirk case as well.
Great to be with you.
All right, folks, yes, that's what I was going to ask for, the applause for David Katz. He's well deserving of them.
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.